Christy, do you think this question of whether Jack Smith's appointment is constitutional is worthy of the level of scrutiny and time Judge Cannon is spending here? I mean, she's not only spending a whole day on it, she's also calling in outside legal experts, I guess she would call them.
Yeah, none of this is necessary. When you go to a meeting and you say that meeting really should have been an email, this is a hearing that really should have been an order, a summary order that was just denying Trump's motion. I think the statutory text is clear, and to the extent there are any questions about the statutory text giving the AG the authority to appoint a special counsel, U.S. v. Nixon cleared that up. This is the Supreme Court saying that's what the statute said. And other courts have followed that since. Appellate courts have followed that since. So why this district court judge thinks that she would have a different interpretation when the Supreme Court has already addressed it and appellate courts have already addressed it is beyond me. And really, it seems like the only basis that I can think of for why you would have all these outside parties coming in who are making crazy arguments. The outside parties tried this, actually, in the Supreme Court when they said you shouldn't even listen to the presidential immunity petition because Jack Smith has no more authority to argue before this court than Taylor Swift does. That's ludicrous. You don't need a law degree to know that's a ludicrous argument. She should be laughing this out of court. They should have not been even allowed in the court to make this argument. But again, delay is the name of the game here. And rather than talking about Donald Trump's egregious conduct in the classified documents case, we're talking about Jack Smith. It's deflection, it's distraction, it's delay, and it's unnecessary.
Lisa, what about this argument that Trump's team's trying to make that the special counsel has too much independence from the Justice Department and would make him essentially a superior officer, and he's not somebody who has been appointed and confirmed by the Senate? Is there any merit to that argument?
If past is prologue, there isn't, Anna, and here's why. What we see today as special counsels was preceded in history by an independent counsel statute that has since lapsed. When we had independent counsels like Ken Starr, for example, they operated with much more independence from the Department of Justice than today's special counsels do, and yet they were still found by courts to be sufficiently inferior officers to have been constitutionally appointed.
There have been so many things that this judge in the classified documents case has done that has raised eyebrows, I think you could say, Kimberly. Let me tick through some of the other decisions this judge has made. It goes back to even before Trump was indicted. She appointed a special master to review the classified documents that were seized from Mar-a-Lago, which an appeals court that had two Trump-appointed judges on them later rejected unanimously. They slapped her down for that. And then she asked both Trump and the government, since she's gotten this case, to submit jury instructions, which experienced lawyers said was odd, especially the timing of those, since we don't have a trial date yet. She keeps entertaining these defense motions that other legal experts say have no merit. Back in May, she said she couldn't even set a trial date, delaying the whole trial indefinitely, even though both parties had said they would be ready for the trial as soon as the summer. And then yesterday, we learned she was asked to step aside by other federal judges and said no. What are people supposed to make of all of this?
Yeah, I mean, look, she is relatively new in this type of role. She doesn't have a lot of experience in trying cases, period, let alone one as complex as one being brought under the Espionage Act. But at the same time, that in itself is not a transgression. Every judge is new at some point. But what she is showing time and time again with all of the things that you just laid out is that she seems to be someone who gets easily diverted, focuses on sort of the minutia of a case, and that sort of paralyzes it and slows it to a halt. This is something that other judges and other litigants before her have said they've experienced in the past, and we're seeing it again here in this case. Perhaps that is one reason why she was cautioned against taking this case when it was assigned to her. But, you know, particularly this argument today, and also this other argument about a law that has nothing to do with this case, which is still pending. It's an order that is still a motion that's still pending before her and has been for months, are evidence that something is really amiss here, in my opinion.
Christy, has this judge done anything that has crossed a legal or ethical line that would warrant Jack Smith to try to now get her removed from the case?
No, not yet. And I think the reason not yet is because a lot of times she doesn't actually make a decision. She punts the decision and says, well, you know, I'm not really sure I want to decide this yet. Maybe down the line, I'll take a closer look at it. And she does that, I think, intentionally so that she can't get appealed and they can't bring it up to the 11th Circuit. And because she has continued to insulate her decisions in that way, it seems very nefarious. Again, if you want to make a decision and you believe that you've made the right decision, you've done all of this analysis, then stand by that decision, make it, and have it be appealed if the other side, if one of the parties disagrees with it. But she doesn't do that. It just seems very calculated for somebody who seems to be, you know, new and inexperienced. It seems like she has given a lot of thought to how to try to insulate herself from review.
Let me pivot now to developments here in New York, where the Manhattan DA, Alvin Bragg, just filed a response or a motion to try to keep a gag order in place for Trump. In this new filing, Lisa, he writes, quote, the recent threat activity directly connected to defendants' dangerous rhetoric about this prosecution includes bomb threats at the homes of two people involved in this case on April 15th, 2024, the first day of trial. It includes an online post depicting sniper sites on people involved in this case. And it includes other recent online posts and communications directed to the attorney, the district attorney, or DANY employees involved in this prosecution that we will kill you all. This is really remarkable stuff.
It's really remarkable stuff, and it's also very necessary stuff, because in moving to lift the gag order, one of the things that the Trump attorney said was all of the data that had been provided by the DA's office to try and justify that component of the gag order that was geared toward protecting the career prosecutors, their families, courthouse staff, that data all came from 2023, and they pointed to a February 2024 affidavit by a gentleman at the NYPD named Nicholas Pistilli. Well, Mr. Pistilli now has a new affidavit dated today in which he is providing the information that you just cited. He also says that of 289 threat cases that have been logged by the NYPD's Threat Assessment and Protection Unit, 61 of them involved threats to the DA. So far this year, in 2024 alone, 61 threats to the DA's office alone. And then he goes on to say that 4 of them were referred for further investigation in partnership with a prosecutor's office. I take that to mean those threats emanated from outside New York and therefore justified the involvement of a prosecutor outside New York. We know that one of them, for example, came from a man very far outside New York on the west coast of the country who was killed earlier this year in a standoff with the FBI, but who had issued a threat of that nature, a very serious death threat to the DA. So this is the DA's attempt to keep the gag order in place with respect to the counsel in the case. And I should note that while the threats are often geared toward the DA himself, he is not someone who is covered by the gag order. The president, or the former president rather, can continue to speak about DA Alvin Bragg, and they point that out as well, and saying that the gag order is somehow a collusive activity between President Joe Biden and Manhattan DA Alvin Bragg toward the president's political opponent, former President Donald Trump. That claim is a lie, is an exact sentence that appears in this brief. No stronger language I can think of that has appeared in this case to date. And I'm pressed to think about language that strong from a government office in any case I've seen before.
Yeah, the words, that is a lie, that claim is a lie, taking on that allegation that Trump keeps putting out there that in some way the district attorney has been colluding with the Biden administration. Kimberly, does any of this have any bearing on Trump's sentencing next month?
It possibly could. It could, if he is seen to continue to violate the terms of his current gag order as it's being considered. It also can have repercussions in terms of his release qualifications in the other cases. But I want to point out something that's really important about what Lisa is talking about. The reason that this motion is so strong and contains all of these issues is that the First Amendment, really, the First Amendment protections of someone, particularly a political candidate, is really strong. And so it's one thing to have a gag order during the process of a trial. It's an even higher standard to have one after the trial is concluded. And you can clearly see here that the DA is trying to make that case and say, yes, this is unusual and he has First Amendment protections, but there are limits when it comes to people's safety.
Kimberly Akinsour, Lisa Rubin, and Christy Greenberg. Ladies, thank you all so much. Up next,